All right. Hello, everyone, and welcome to our virtual fair housing workshop for landlords and property managers. My name is Chris Robinson, and I am a senior planner with the City of Houston's Housing and Community Development Department. We are absolutely ecstatic that you are all joining us, along with our two special guests, as we discuss our housing providers' responsibilities under local and federal fair housing laws. Just a note, we will be recording this presentation. It will be posted to our website in the coming days, so please check out our website for the workshop materials, but we'll also be sending the presentation materials via email today. Lastly, just want to note that your microphones are muted as well. Your cameras are also disabled, but you can type a question at any time in the chat, and we will address those during our Q&A period. So while we are waiting for attendees to jump on, we want to do a quick poll. Can we get the next slide? Great. So, whether this is your first time or if you are a seasoned housing industry expert, we just want to know on a scale of 1 to 5, tell us just how confident you are about understanding your fair housing responsibilities and how they should guide your decision making as a housing professional. One being, I really don't know what my responsibilities are or how they apply to my work. Three is, I sort of kind of know. And three is, I absolutely know. I'm confident about my responsibilities and how to appropriately apply them. And you can drop that number in the chat. And it's okay if it's a 1 or 2. That is why we're here. I do love seeing these 4s and 5s come in, though. Okay, Emily, I see a 3. Great. Thank you, Raina. Monica, that's okay. I'm glad you're here joining us. This is why we're doing this workshop. 5s, 4s, great. Awesome. Thank you guys. And keep dropping those numbers in. I just want to get a gauge of where our knowledge base is. Thank you all. All right, so today you're going to hear from Ms. Kimmy Johnson, who is our Fair Housing Administrative Coordinator at HCDD. She is the absolute brains behind this operation, so we're glad to have her presenting information. Following her, you will be hearing Mr. Howard Bookstaff, who is an equity partner and a real estate attorney with Hoover Slovacek. And he has also been a general counsel for the Houston Apartment Association since 1995. And he's often representing clients that own and manage real estate properties. He's also a fair housing trainer with the Texas Department of Housing and Community Affairs. And he speaks for landlord, tenant, and fair housing seminars often. After Mr. Bookstaff, you will also hear from Mr. Velimir Rosic, who is a staff attorney with the Lone Star Legal Aid's Fair Housing Team. Mr. Rosic has spent more than a decade in legal aid representing low-income clients on a variety of civil legal matters, including evictions, consumer and family law, bankruptcy, and disability rights. And he primarily works with vulnerable children and adults, which sheds light on the importance of access to justice and the profound impact that quality representation can have on the lives of those who need legal assistance. And so, to say the least, we are very grateful for both of these special guests joining us. We are happy about the passionate work that they do, and we are excited to hear from them the information that they've prepared for us today. So, thank you both, Mr. Bookstaff and Mr. Rosic, for joining us. We also want to make sure that as our property managers and landlords are doing their great work, that they are also aware of our Houston Harris County Rental Assistance Program. While we have nonprofits who are helping to administer this program, it is a jointly funded program by the City of Houston and Harris County, which provides rental assistance for tenants who have been impacted by COVID-19, and they may also cover rental arrears and future rent for up to 3 months. We are encouraging all of our landlords and property managers to enroll in this program today so that we can continue to streamline the application process for our tenants. And for more information, you can always visit HoustonHarrisHelp.org, or you can call our hotline at 832-402-7568. On the agenda today, Kimmy will be discussing some fundamentals about fair housing and how to identify basic housing discrimination, how to apply for or how to apply the information to advertising and property policies. And Mr. Bookstaff will take about 40 minutes to discuss our reasonable accommodations and modifications, as well as assistance animals. And then we'll hear from Mr. Rossick, who will address immigration, LGBTQ plus protections, fair housing complaints, and eviction basics. And then we'll close things out with a Q&A. And we just want to remind everybody that the information that's being provided today does not constitute in any way legal advice. We are providing informational material to you all. So if you do require legal advice, please contact an attorney for assistance. And now I would like to welcome our resident fair housing coordinator, Ms. Kimmy Johnson.
Thank you, Kristen, and thank you all for joining us today. So let's just get right in there. Let's talk about fair housing and why it is so important. So, Houston is a majority renter city, and with over half of Houston renters paying more than 30% of their income in rent. And of those, 51% of renter households pay more than half of their income in rent. And we refer to this as cost burdened. So, a family that is cost burdened means that they have fewer resources to pay for other needs such as their health care, education, or food. So, now let's talk about how much it really costs to live in the city of Houston. The minimum hourly wage in Texas is only $7.25, which means that a minimum wage worker would have to work 115 hours a week to afford this type of rent, which means that they'd have to work three full time jobs. So Houstonians must earn about $21.02 an hour to pay for an average two-bedroom rental home. The Fair Housing Act, passed in 1968, is a civil rights law that was created to put an end to housing discrimination. I'm sorry, to discriminatory practices in any activities that are related to housing. And the act ensures that every person has the right to rent a home or purchase a home or obtain a mortgage without fear of discrimination due to their membership or perceived membership in a certain class. So, where you live truly matters because housing plays a significant role in determining your quality of life because it directly affects your access to the transportation and your recreation in neighborhoods, the housing that's within your budget, and your social, cultural, and educational opportunities, as well as where you work, your medical services, and entertainment opportunities. So, just an example of children whose families move to the neighborhoods with better access to opportunities by age 13 earned higher future earnings than their peers and had higher college attendance rates. So, housing discrimination restricts the access to those opportunities. And fair housing trainings like this one, like the one we're doing today, they are especially important because the majority of fair housing complaints come from rental housing transactions. And of those, the two most reported types of complaints are discrimination based on disability and race. So, the Fair Housing Act covers a number of processes around housing and housing transactions, and those include the rental or sale of housing, housing services and facilities, advertising, which we'll talk a little bit more about today, lending and insurance, reasonable accommodations and modifications for people with disabilities and for those with limited English proficiency, as well as protecting residents from harassment and retaliation. So these are the protected classes, and housing professionals may agree that discrimination towards protected classes may not generally be as obvious as it was about 50 years ago. However, it's still an ongoing problem. And it's really important to know the difference between each protected class in order to ensure that your tenant selection process and overall housing policies don't discriminate based on membership in any of these groups. So, to review them really quickly, they are race, color, national origin, familial status, religion, disability, and sex. And this January, under the president's executive order, HUD announced that it will administer and enforce the Fair Housing Act to prohibit discrimination on the basis of sexual orientation and gender identity under the protected class of sex. So, our special guests are going to cover this in a bit more detail later in the presentation. But today we cover the protected classes just very briefly for the sake of time. But if you would like more information, please do not hesitate to reach out to our office. And we'll provide that contact information at the end of the presentation. So now we'll move to identifying housing discrimination. With that, it's important to understand how fair housing laws do impact your policies and daily practices. And by becoming familiar with these following guidelines, you can maintain in compliance with the law and conduct your business with fairness. Let's jump into it. So, what does housing discrimination look like? This slide is just an illustration of some of the common discriminatory practices that can take place in rental housing transactions, and we're going to touch on each one of the next few slides. So, here are just a few examples of some commonly used statements that may be considered discriminatory. And such statements may be overt, such as, "We don't rent to your kind of people." However, often discrimination is hidden in plain language, such as, "Oh, if I were single like you, I would rent where it's safer." Or, "I don't think you'd be happy in this neighborhood." Or, "Would you feel safe living here on a busy street like this with young kids?" Or even, "Typically, we reserve these first floor units for our tenants with younger kids." So often, this language is used to dissuade certain tenants from inquiring further about a rental, and it's illegal. Advertising. So you may be wondering, why are fair housing guidelines for advertising even a thing? But the fact is, if you work in the housing industry, regardless of your position, you're most likely advertising on a daily basis. So HUD provides advertising guidelines for compliance, which we're going to cover in the next two slides. Advertising under the Fair Housing Act includes anything that you make or you print or publish, and such as it can be applications, brochures, signs, billboards, posters, or even pictures that you have in your office. It also includes such things that you mention about your property via email or over the phone or in person. So the ads may describe the attributes or amenities of the property. They should avoid describing the type of person who should reside there. So there are certain buzzwords that you should avoid using because they've been associated with discriminatory practices in the past. And words are like restricted, exclusive, limited, and so forth. So, for instance, you can't advertise that housing is only for a certain racial or ethnic background or exclude families with children with ads that say no children. So your promotional material should include a variety of the protected classes. For instance, just because the neighborhood that's surrounding your property is made up of residents of a certain background or the majority of your tenants have a similar background, it doesn't mean that your ads can be limited to just those individuals. So we say that landlords should provide truthful information about the availability, the price, and amenities and features of a housing unit and ensure that your policies and procedures are up to date. The Fair Housing Act itself does not require the use of the equal opportunity logo that you see here or the slogan equal housing opportunity in any ad. However, using the logo regularly is good evidence of your company's commitment to fair housing compliance, so it is recommended. The criteria that you use to determine whether a person is qualified to rent a home should also be objective and applied consistently to all home seekers. And it's a good practice to have a written policy that contains this criteria. And it may also include occupancy guidelines, the availability policy, and an outline of the application process. So, in order to determine if someone is a qualified applicant, questions can be asked regarding their income, an applicant's employment history, their credit, criminal history, and rental history. But it is important to offer the same terms and conditions to all applicants, which includes the deposit of fees, lease terms, and access to their amenities. But to avoid trouble with fair housing laws, just be sure to be consistent and fair in your screening. Steering happens when a landlord or real estate agent attempts to direct a home seeker to a particular area based on their protected class. So, in the rental market, this includes directing a particular tenant toward one section of the apartment complex or to a particular floor. So, discouraging someone from living in a particular neighborhood by exaggerating the drawbacks or failing to mention amenities can also be considered steering. But to avoid steering, it's best to show all available properties to all home seekers and allow the home seeker to make the decisions about which property should be viewed or if the property is a good fit for them. In addition, housing professionals should only present the facts about a property, not about the residents or its neighbors. So, home seekers would often inquire about a neighborhood or ask information about the schools or the crime or the demographics, but you should only direct them to reliable resources such as the local school district website, the police, or the Census Bureau to obtain this information. So now we're going to cover property rules and policies. So, with regards to property rules, it is acceptable for landlords to have a set of basic and non discriminatory house rules for residents to follow, but rules must be enforced and uniformly for all residents, and records regarding rule violations should be kept. So, all details need to be included in the records, like the date and the time and the manner of the violation, and how you, the landlord, became aware and what actions were taken to enforce the rule. And finally, access to common areas, including the pool, the gym, the laundry facility, should not be restricted for certain residents, such as children or persons with disabilities. And so, this is an area where language access can be a problem, but a best practice would be to translate the rules into tenants' native languages and don't rely on minor children to communicate the property rules to parents. Housing professional providers are responsible for the behavior of their staff, and it is recommended that an anti harassment policy be created, distributed, and enforced. And so, harassment can include verbal or written comments, threats, offers to exchange services for sexual favors, or destruction of the property. But tenant on tenant harassment should also be taken very seriously, and any behavior that violates the resident's code of conduct should be documented and appropriately addressed. So staff should respond in a timely manner and have consistently enforced the policy and involve law enforcement or other resources when necessary. And last but not least, training and compliance. All employees are required to comply with fair housing laws, including maintenance and office staff. But fair housing training should be provided for all employees and incorporated into the training process for new employees. The policy should be documented and communicated to all employees and may need to be reviewed on a regular basis. Owners and landlords can be held responsible for the actions of their employees and may be held responsible for their team's discriminatory statements and behavior. So, this concludes this portion of the presentation. And at this time, I'm going to turn it back over to Kristen to introduce our special guest. Kristen?
Thanks, Kimmy. Wonderful job wrapping up all of those fundamentals of fair housing and how to apply them even to your advertising and your property rules and policies. So now I'm going to turn things over to our first special guest this afternoon, Mr. Howard Bookstaff. If you are ready, please take it away.
Thanks, Chris. Great job, Kimmy. Thank you. First of all, thank you very much for allowing me to present. Thanks to the city for allowing me to do that. I really enjoy teaching fair housing, doing fair housing training, because fair housing really affects everything you do. As Kimmy pointed out, it deals with advertising, it deals with enforcement, preparation of rules, enforcement of leases, enforcement of rules. and of course the eviction process. So I'm going to delve into some of that, and Belmer will follow up with more of it. The first thing I want to point out is, and I'll talk about this more when we talk about assistance animals, which I know a lot of people have interest in. HUD came out with a guidance, a notice, they call it, January 28, 2020. We started to train in late January and February and beginning of March, and then something happened about the middle of March that ceased all our training. So I'm still excited to talk about the January 28, 2020 notice. And one thing it says in there is, it says at the date of the issuance of this guidance, so it was January 2020, Fair Housing Act complaints concerning denial of reasonable accommodations and disability access comprise almost 60% of fair housing complaints. And those involving requests for reasonable accommodations for assistance animals are significantly increasing. So the first part of that, 60%. So Kimmy went through the protected classes: race, color, religion, national origin, sex, familial status, and disability. Well, you may not realize it, but disability, as HUD tells us, is 60% of the complaints. So it seems really relevant to know that in our training, because what I want to do is talk about disability complaints. And that's really what you need to learn, right? Because the other aspects of the protected classes, while you still have to learn that, a lot of it seems to be a basic right and wrong concept. But in disability, there's a lot of things that you don't know, just it's not innate to know it. You have to be trained on it. So let's get started. Next slide. This is the same thing that Chris talked about. Can't give you legal advice up here. If we have 100 or so or more participants, nothing I say is confidential. It's being recorded, and there's a lot of so nothing I can. And when we answer questions later, nothing we're going to say should be deemed to be legal advice, because we can't give you confidential information or specific advice about your specific situation. But we can certainly give you general thoughts that you can then take to others in your company, your professionals that you rely on, and so forth. Next slide. So getting into the concept of disability discrimination, what is key to that concept is this concept of reasonable accommodations and modifications. So we see a lot of complaints, and we handle a lot of grassroots complaints where it's just a complaint with the Texas Workforce Commission, Civil Rights Division, or it's a complaint with HUD, or some local agency where somebody, a resident or an applicant, has filed a complaint saying that that the housing provider has discriminated, and we have to deal with that. A lot of those complaints deal with either misunderstandings, miscommunications regarding the provision of reasonable accommodations and modifications. So we need to delve into what is that and how do we deal with those type of requests. Next slide. So principal key to any request for an accommodation or a modification is the person has to be disabled under the Act. So that makes a lot of sense. What is a disability under the Act? It's a person qualifies for the disability if the individual has a physical or mental impairment that substantially limits one or more major life activities. So that has three parts, and I would memorize that first sub-bullet point. 3 parts to it. So a disability is not just a physical impairment, not just a mental, it's both. Physical or mental impairment that substantially limits. Now I look at each word here and think it has meaning. Each word has meaning. Substantially limits. Doesn't say that limits, It doesn't say that sort of limits. It substantially limits. So physical or mental impairment substantially limits what? One or more major life activities, not one or more activities. It doesn't prevent you from going to the Texans game on Sunday, and you can do everything else. It doesn't prevent you from, going to a local restaurant. It is major life activities, which is, eating, breathing, sleeping, being able to take care of yourself, clothe yourself, work, the major life activities. So that's there's a list that HUD gives you, but it's not exclusive. So it's up to each individual case to determine whether this ailment, this physical or mental impairment, substantially limits one or more major life activities. But it's got to have those three things for the person to be disabled. It also says individuals who are regarded as having such an impairment, individuals with a record of such an impairment. So it's a little vague and a little broad, but I think the key is that first sub-bullet point, physical or mental impairment that substantially limits one or more major life activities. Next slide. So the concept of reasonable accommodation. A reasonable accommodation is a change, this is out of HUD rules, is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. So what does this mean? That's what HUD says. Now, what do we think it means? Well, it seems to me to have a reasonable accommodation, you have to have two things. One, you have to have a rule, policy, or practice or service that we're talking about. And then you need a request for some change, exception, or adjustment to that rule, policy, or practice or service. So if somebody says, and we've had complaints, all types of complaints we've dealt with, and one common complaint is someone's a resident upset that they didn't get repairs made in their unit. I had my air conditioning broke down, it's the middle of August, and therefore I'm disabled, and I asked them to fix it right away. They discriminated because they didn't fix it. Okay, well, on that scenario, what is the rule, policy, or practice or service? We fix air conditioners upon request. They didn't really ask for an exception to that, so it's not a reasonable accommodation request. Now, it is something you got to fix. There's other laws that says you have to repair remedy conditions in the unit, but it's not really a fair housing complaint. So on every, and we'll see this in more detail when we get to assistance animals, because what is a request for an assistance animal, by the way, still the headline from that, it's a reasonable accommodation request. That's all it is. It's a reasonable accommodation request under the Fair Housing Act. Okay, so in that case, you've got to have a rule, a practice, policy or service, and you've got to have an exception, a request for an exception to that. So that's accommodation. So remember two things, policy and exception to that. Next slide. Okay, now we have the other side of the coin, which is a reasonable modification request. It can't be both. It's got to be one or the other. A reasonable modification is a structural change made to existing premises occupied or to be occupied by a person with a disability in order to afford such person full enjoyment of the premises. So a modification has to do with a structural change. So to review, an accommodation, you need a policy, an exception, a request for an exception. The modification, you need a structural change. Okay, so what is an example of an accommodation and what is an example of a modification? Well, an accommodation would be, assistance animals would be a classic example of an accommodation. You have a policy where you don't allow, you allow pets, but you have to pay a deposit. I want an exception to the deposit requirement because my animal is my assistance animal. Okay, so that you have a policy and you have an exception to the policy. Modification. Let's say somebody needs a ramp because they're in a wheelchair. They need a ramp from the sidewalk to the door of their unit, or from the parking space to the sidewalk, and then to the door of the unit. So they need that. And what is that? So that's a classic modification. You see the difference. There's no policy at work there. There's no exception to the policy. It's simply a request for a structural change. So that's clearly a modification. Now I ask you, what about a parking space where you have to restripe something? Someone wants an assigned space that's handicap accessible because they have a wheelchair, they have a van, and they need the bigger space. They want it to be a reserved space for them that's handicap accessible. Well, you have to paint, you have to put signage up. Is that a modification, a structural change, or is that some policy that you want an exception to? Like, we don't normally have reserved spaces, so this is an exception to the policy and want reserved spaces, or we have reserved spaces but we charge. This is an exception to policy, so we don't charge them. Well, this is part of it. You don't know, you're not born knowing this. This is something that the courts and HUD have taught us, that a parking space is looked at like an accommodation, not a modification. Okay, now what's the difference if we decide it's an accommodation versus a modification? Next slide. The general rule, and there's some exceptions that may apply to your properties, but we'll talk about the general rule first. It is unlawful for any person to refuse to permit that underlying part there at the expense of the handicapped person. Oh, and let me just clarify here. What's the difference between handicap and disability? Okay, nothing. It's HUD has originally came out and used the term handicap in the original Fair Housing Act. More recently, HUD has said they use the word disability, and they even have a footnote in one of their guidance that says we use the term disability now instead of handicap because it's more politically correct. And I see a question. We'll get to the questions when we're done, and then we'll have time at the end for questions. So please ask your questions. We'll save them in the Q&A or the chat, and then we'll go from there. So the general rule on modification: it's unlawful for any person to refuse to permit at the expense of the handicapped or disabled person reasonable modifications of existing premises occupied or to be occupied by a handicapped person if the proposed modification may be necessary to afford the handicapped person full enjoyment of the premises. So generally speaking, the ramp can be at the expense of the person requesting it. However, next slide. We have some exceptions. If you're a 504 property, that's a property that's subject to the Rehabilitation Act of 1973, you have to pay, the housing provider would have to pay for the modifications, with some exceptions. And I'll go in the slide after next. If you are a tax credit property, you're also going to have an exception because of the tax credit rules. Okay, next slide. So you do have to know if you're a 504 property or if you are a tax credit property. You need to know because you will not be able to charge the person for the modification. So the ramp would be at your expense. Now, for market properties, it goes on. So the resident has to pay for the modification. Where it is reasonable to do so, the landlord may condition for a modification on the renter agreeing to restore the interior of the premises to the condition that existed before the modification, reasonable wear and tear accepted. Another one that you have to learn. If person in a wheelchair says that I need to be able to get and let's say you're built before 1991, which I'll describe in a second, the special rules on that. If a person in a wheelchair says, I have to get from the living room to the bathroom and I need the door widened because it's a narrow door, I need it widened so my wheelchair can fit in there. Is that a modification or an accommodation? Well, it's a structural change, clearly. There's no policy at work here. It's a modification. So can the housing provider, who pays for it? If it's a market property, the resident would have to pay for that modification. What about putting the door frame, the door width back to the way it was at the end of tenancy? Who pays for that? Well, again, it's the interior of the premises, so under this, you could argue that it should be the resident should pay for that. Problem is, the court says that's not reasonable to require the resident to pay for it. There's two caveats in this slide. Reasonable to do so in the interior of the premises. So that is in the interior, but it's not reasonable to do so. So says the courts, because the next person can use it the same way the previous resident could do it. See, that's not something I would know. It's something you have to learn. Similarly, if you have a resident who needs grab bars in the commode, is that an accommodation or modification request? Well, it's modification, right? It's a structural change, okay? Then we go to who has to pay for it. Modifications are paid for by the resident in normal cases, in market property cases. Then we go to, can you charge the resident for taking the grab bars away? Now, based on our door example, you might think, no, you can't, because the grab bars can be used by the next resident just the same as the disabled resident. What HUD has said is you can require the removal of the grab bars, but not the blocking behind the wall, because the blocking behind the wall isn't seen by anybody. And so that's, again, I don't know that you would empirically know that. You have to have been taught that. Next slide. Now I'm talking to the tax credit people. I've only included one slide on tax credit, but you can look at the rules. This is TDHCA rule 1.204, and it goes like 204 to 20. I think the current current numbering is 204 to 207 or 8, maybe 202 to 207. But you can read that. It's all on providing reasonable accommodations in air quotes, because they conflate the two. It says when a resident or applicant requires an accessible unit, feature, space, or element, or a policy modification. So they use the word policy modification, which is not a term the Fair Housing Act used. That would be an accommodation, but the requiring accessible unit, feature, space, that would be a modification under the Fair Housing Act. And it says, or other reasonable accommodation. So they're saying that everything, whether it's a modification of we know of or accommodation, it's all looked at like an accommodation. The recipient is the tax credit recipient, which is the housing provider, you, must provide and pay for the requested accommodation. Unless, so that tells me that every tax credit property, modifications, accommodations, it's on the housing provider to pay for it, unless doing so would result in a fundamental alteration in the nature of the program or undue financial administrative burden. So if some guy, who has difficulty walking stairs rents a unit on the 4th floor of a building that is not serviced by an elevator, and he says, I want you to put in an elevator. Obviously, if you're a market property, you say, well, okay, if you have the space, it's your expense. He'll say, no, thank you, I'll go to the next property. But on a tax credit property or 504 property, you could say, I want you to put in an elevator, it's your expense, but you could say, wait a second, it really is an undue financial and administrative burden for us to put that in. If providing accessibility would result in an undue financial administrative burden, the recipient, you, must still take other reasonable steps to achieve accessibility. So in other words, what they're telling us in the rules is work with your residents. If somebody has an accommodation or modification request in your tax certified property, work with them. And frankly, even if you're not a tax certified property, it's the best way to avoid these complaints is don't piss people off, right? Don't we only see complaints from people that are upset about something. So if you can work with them and accommodate, in lowercase accommodate, what they want, then that is your best going to be your best move from a legal standpoint, because then you don't even get to see us, which is good. Next slide. So I can't leave a discussion of modifications without talking about the rules regarding design and construction requirements. So when the Fair Housing Act was amended in 1989, there was a 2-year or so period where all properties that were designed and constructed for first occupancy after March 13 of 91 had to have certain aspects of design and construction. And I see, please place questions in the chat, not the Q&A, the chat. So what are covered multifamily dwellings and what do they have to have? Well, covered multifamily dwellings, so this is for the people whose property was built for first occupancy after March 13 of 91. And this, I think, is getting to be more important because we have more properties each year. We kind of lose the older properties. We have more properties that are built after 91. So if that's the case, your property should have been built with all covered multifamily dwellings, which are ground floor dwelling units, and all public and common use areas in the building with 4 or more dwelling units and no elevators. So if you have no elevators, all the ground floor units should be accessible. If you have an elevator, well, that means all units should be accessible because you've created a mechanism by which somebody on the ground floor can transport in a wheelchair all the way up. So all floors. Now, what is the required accessibility features? Well, the public and common use areas must be readily accessible to and usable by persons with disability. So if you have a barbecue pit, if you have a playground, it ought to be accessible. Picnic table, it ought to be accessible to somebody in a wheelchair. So we've actually been hit with complaints where the property owner had a barbecue pit that was on cement, but there was grass around the pit, around the cement area. You need to have it accessible. We've had accessibility built into the way the property was built, in the sense that it has accessible route throughout the property by sidewalks and cement, so somebody in a wheelchair could maneuver about the space, but they had shrubbery growing in the sidewalks, into the sidewalks, which made it impassable for somebody in a wheelchair. Well, you want to make sure you don't have that, right? You want to be accessible. Then we go to inside the unit, doors designed to allow passage into and within all premises of covered dwellings must be sufficiently wide to allow passage by persons with disabilities, including persons who use wheelchairs. So if you have that example that I had where somebody can't get from the living room to the bathroom because it's a narrow doorway, and you were built after 91, even if you're a market property, you can't charge for that change because the property should have been built with that wider door anyway. So you want to go ahead and correct that issue if the property was built after 91. Before 91, you could treat it like a normal request for a modification. Then we have all premises within the covered dwellings must contain certain features of accessible design. The accessible route into and through the dwelling unit, light switches, electrical outlets, thermostats, other environments. So the thermostats have to be at a certain height, reinforcements in bedrooms that allow installation of grab bars, usable kitchen and bedrooms. Now remember, all these things, if the property is not built with those things, we had cases where, and usually in cases properties built in the 90s, I think we learned our way in the properties built after that they definitely comply with this. But early lawsuits were pretty big lawsuits because it takes a lot of money to, reconfigure walls and kitchens and all that after the fact. So it became a big deal, big money lawsuits on this. We've seen a lessening of those lawsuits because I think properties are being built with that in mind now. Next slide. Okay, now let's talk about responding to requests for accommodations and modifications. Next slide. The first thing before we get to, we're going to create a response, but the first thing we have to get to is HUD makes it very clear you can request but not require that the request for a modification or accommodation be made in writing. Okay, in other words, those of you that have forms that you give to people, if they don't fill out your form, you can't say no because they didn't fill out your form. Because, again, the request cannot be required to be in writing. Even HUD recognizes that it's a good idea to get it in writing, but does not require it. Next slide. Okay, so real quick on the responding to a written request, the way I would suggest that you respond to a request, this is all me doing it, there's no HUD involvement here. I would suggest that you follow this guideline. Reiterate your policy. What's your policy? We comply with the fair housing laws. And then I would go further. If it's an accommodation request, I'd say accordingly we provide, reasonable, we make accommodations for you, equal opportunity to use and enjoy. Use the words that HUD uses. If it's a modification request, accordingly we will allow you at your expense, if you're not tax credit or 504, at your expense to make modifications. That for the first time, the person requesting may understand, they may not have known this, that they have to pay for the modification. So that's to reiterate your policy. Then I'd confirm the request. You need to make sure you're responding to the right thing. So what is the request? My understanding is you have requested, and this covers you even if they made an oral request, you're putting it, you can put it in writing. You can't require them to put it in writing, but you can certainly do that. And so that's what you're doing here. Confirm the request. Then you need to respond. You got three options: grant, deny, or request more information. I will tell you that I err on the side of not denying. I would not suggest you deny. I would suggest that if you're inclined to not accept it, not grant it, then I would request more information. So then we get into what information can you request? Next slide. Okay, in response to a request, this is out of HUD statements. In response to a request for an accommodation or modification, a housing provider may request reliable, so I start here, reliable disability-related information that, number one, is necessary to verify the person meets the Act's definition of disability. As I said before, you don't get any accommodation or modification unless you're disabled, because that's what the Fair Housing Act is about. It's about the disability discrimination. That's what the accommodation modification is about. Number two, reliable disability-related information that describes the needed accommodation or modification. You need to describe the accommodation. Three, reliable disability-related information that shows the relationship between the person's disability and the need for the requested accommodation or modification. See, there's three things. This should make perfect sense to you. Verify you're disabled under the Act, describe what you're asking for, and we need to know the relationship between the disability and what you're asking for. That makes sense. Let's take this to an assistance animal situation before we get to that slide. Actually, the next slide is assistance animal, but let's stop on this slide for a second. In assistance animal jargon, we usually know what they want because they tell us they want Fluffy the pit bull, and that's what they want. So you know that part. But you need to, especially with emotional support animals, it's not readily apparent what your disability is. So you'll need to provide us with some reliable disability-related information verifying that you meet the Act's definition of disability. And then really important, which we have a lot of questions on assistance animals, is the relationship between your disability and the need for the animal. In other words, what is your disability-related need for this animal? And that's going to be key to our assistance animal analysis. Next slide. Next slide. So now we'll go into assistance animals. In the January 28th guidance, which I have mixed opinions about, sometimes it was designed to clarify. Good goal. Sometimes it did clarify, sometimes it just used different words to say the same thing that they said before. One of the things they did, which I don't think is particularly helpful, but we'll tell you about it. They described the world of assistance animal consists of two types of animals. One is a service animal, which is only a dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. So if you think you have a service cat, you don't, according to HUD. Now, you don't stop there. The cat could still be an assistance animal because it doesn't just, service animals are one thing. Those are the dogs with the vests, that help the blind, that help, that are specifically trained to help a certain type of disability. That's a service animal. That's kind of the classic service animal. But then it opens it up to any other animals, monkey, goldfish, snake, whatever. Any other animals that do work, perform tasks, provide assistance, or provide therapeutic emotional support for individuals with disabilities. We don't have many questions about service animals. We know those. The questions often come up with respect to the other animals because that's so vague, right? That's got a lot of things. Now, one thing in the guidance, reading now from the guidance, HUD is providing this guidance to help housing providers distinguish between a person with a non-obvious disability who has a legitimate need for an assistance animal and a person without a disability who simply wants to have a pet or avoid the costs and limitations imposed by housing providers' pet policies, such as pet fees or deposits. So HUD is recognizing that there may be instances where somebody's asking for an assistance animal. It's probably not going to be a service animal because those are clear, but they're asking for an assistance animal where they're just trying to skirt your policies, not pay the deposit, not pay the additional monthly fee or the non-refundable pet fee. And so your job, if you choose to do it, is to determine when you get such a request, how do we decide whether it's, one of the legitimate requests or one that's just somebody trying to skirt the policy we have of paying the fees or a breed restriction or a number restriction or whatever. Because remember, breed size and number limitations would not apply if it's a legitimate assistance animal, which again can be any type of animal that works, provides tasks, provides assistance, or provides therapeutic emotional support for individuals with disabilities. Next slide. So the service animal questions you already know, right? If not readily apparent, is the dog required because of a disability? And this, again, I don't focus on this, but I tell you it because HUD said it, but it's a service animal thing. You probably don't have issues with a legitimate, specially trained service animal. You'll know it when you'll know it when you see it. Next question. Next one. Now it becomes questions to ask if the animal is not a service animal. In other words, it's just a normal other assistance animal. If not readily apparent, does the person have a disability? You have to know that. If not readily apparent, does the animal work? The same words that I used before, it's got to be some connection to that disability. Next slide. Now, to show the disability, HUD has said you can use if the person has a predetermined, government determination of disability, such as receiving disability benefits or services, Medicare, Social Security, insurance benefits, eligibility for housing assistance or voucher because of a disability, that would, in and of itself, means they're disabled. Doesn't mean they get the assistance animal yet. They still have to go that other prong, which is the relationship between the disability and the need for that animal. But they have the disability if they have a government determination of disability. Makes sense. And then the tough one is the last bullet point. You can get confirmation of a disability from a healthcare professional, which is it's not exclusive list, but physician, optometrist, psychiatrist, psychologist, physician's assistants, nurse practitioner, or nurse. So they give you that list that you can, a letter from them is not going to be bad just because it's from that person. So if it's a nurse practitioner, it's fine. But does it give you the information you need? Next slide. HUD has also said this is from the January 28th guidance, some websites sell certificates. They talk about documentation from the internet. Some websites sell certificates to anyone who answers certain questions or participates in a short interview and pays a fee. Such documentation from the internet is not by itself sufficient to reliably establish that an individual has a disability or disability-related need for an assistance animal. So those first two bullet points are terrific for those that don't like the 64.99, 99.99, sales pitch that the doctor in Oregon, where the resident's never seen that doctor, just answered a few questions. Are you disabled? Yes. Do you have a disability-related need for your animal? Yes. Done. You get a certificate. The HUD has recognized those are not going to be valid. But then HUD goes on to the last two bullet points. By contrast, many legitimate, licensed healthcare professionals deliver services remotely, including over the internet. One reliable form of documentation is a note from the person's healthcare professional that confirms a person's disability or need for an animal. When the professional has personal knowledge of the individual. So that's what we're looking for. We're looking for some sort of evidence based on the letter we get that the physician has personal knowledge of the individual. Okay, and we've seen all types of things. Most recent, and every week we get them. So this week's version, we've had a couple things. We've had two separate people that are co-applicants, so they're going to live in the same unit, but two separate people. They submitted. They each want their own separate cat, and they submitted an identical letter from the same service provider with different dates that only changed the name of their cat and the name of them, but they had the same. It very clearly was a form letter, so it had the same disabilities, the same exact words used, and it's like that just feels like like you don't have personal knowledge, and that's what's credibility issues with us, and so we push back. But that's the kind of thing you have to look at, is like your Inspector Clouseau trying to get you'll take whatever they give you. You can't identify what they can and can't give you. You can just evaluate everything and then decide, do they have a disability under the Act? Do they have a disability-related need for the animal they're requesting, based on what you get? So that's your job to do if you want to push back. Next slide. What is reliable information showing a disability-related need? HUD states that reasonably supporting information often consists of information from, and it gives us the same list of healthcare professionals. Information needs to be specific as to the individual with disability and the assistance or therapeutic support. So specific as to the individual with a disability. A form letter that some of my properties, some of my properties have gotten the same letter to them, or totally different applicants that may not know each other, but it's some doctor that set up a website. So clearly we know that's not specific as to the individual, and it must show a relationship or connection with the disability and the need for the assistance. Next slide.
Staff, you have about 5 minutes.
Got it. Thank you. Housing providers may ask for information to conduct an appropriate individualized assessment. That's what you're asking for. One thing that I put in here that's from the guidance too that is very important, because I see people pretty close to not complying with this. Housing providers may not require a healthcare professional to use a specific form. Okay, so if you're requiring a doctor to fill out a form and you won't accept anything else, I don't think that's compliance with this, because you're requiring them to use a specific form. To provide notarized statements, if you're requiring them to provide under oath, or some do it under threat of penalty of perjury, you can't do that. What they don't want, I think the intent of this is they don't want you to provide undue influence over the independent decision and determination that a healthcare professional should be making with respect to the diagnosis. Because that's what I would consider this to be, a diagnosis, to have an emotional support animal, to have an assistance animal. So you have a health issue, mental or physical, and then you have the diagnosis of what you should do about it. Next slide. So you won't see this in the HUD paperwork, but we had a court case out of a federal district court in Texas, 2017, that actually supported a landlord pushing back. The court evaluated therapist letters and concluded that they presented no medical facts or support that claimed disability. The letters stated very close to things that we see every day. The resident needed the applicant needed a therapy dog to cope with their mental health condition, had a mental illness such as such had certain limitations. Next slide. Was impaired by her mental illness and met the definition. And the court said that's not good enough. The letters identified no activity, no less a major life activity. Remember that definition, that the resident claimed to be impaired by her mental illness. The information provided failed to set forth any facts regarding how the resident's condition substantially limits. Again, that's why I wanted you to memorize that physical or mental impairment that substantially limits one or more major life activities. The court actually used that definition, used words in that definition to support its ruling that the landlord could push back successfully. Now, I will tell you, if you decide to push back, recognize you may draw a fair housing complaint. If you say yes to everything, you run the risk. If you grant everything, you run the risk of losing your pet policies, okay, that everybody will come. So you got to make that balance, that decision. But if you're going to ever push back, please know in your mind what yes looks like, okay, because otherwise you just don't look credible if you're always pushing back every time. So you got to know what yes looks like in a legitimate case, okay? So have that, and obviously a lot of vague terms here. You got to talk to your other people in your company, talk to your professionals about what yes looks like and whether you can push back and how to push back. Next slide. Final slide, I wanted to briefly talk about HUD's guidance on the application of Fair Housing Act standards to the use of criminal records. You can actually Google this. It's called that, HUD's guidance on application for Fair Housing Act standards to the use of criminal records. I would suggest that you look at this before you or look at this and compare it to your existing criminal history screening policy. What it says is a criminal history screening policy could be discriminatory even if you have no intent to discriminate. Disparate impact discrimination is you don't have intent to discriminate, but it has a discriminatory effect. And HUD has said criminal history screening background check policies could be discriminatory. Okay, so the key is to make those policies as least discriminatory while still addressing your legitimate concerns as to why you don't want people with a certain background on your properties. And HUD suggests look-back periods on specific types of crimes, and breaking down specific types of crimes as far as what is a no-go for your property, what is okay if it hasn't happened in 10 years or so, or some look-back period, and then what is not a problem. Like if you had a traffic ticket, that may not be a problem, even though that's a crime. But you'd be clear on that. And with that, I am right on time, I think. So I give it back to you, Chris.
Thank you so much. Impeccable timing. I just want to say I think the Court of Public Opinion has decided that you are a great presenter. So thank you so much for capturing our attention and giving us great information. So right now, guys, we are going to take a brief 2-minute break. And just to note, we will get to some of your questions during the Q&A period, which will happen after Mr. Rossick speaks. So right now it's 3:06. Take a couple of minutes for a stretch break, coffee break, or you can just stare into space, whatever you like, and we'll return at 3:08, guys. All right, everyone. Thank you for staying with us. We're going to get right back into this presentation. And right now, we're going to hear from our second special guest, Mr. Velimir Rossick, who will be discussing the intersection of fair housing and tenants' rights, along with some eviction basics. And with that, Mr. Rossick, I turn it over to you.
Hello, everyone. I'm Velimir Rossick, very happy to be here. Today, we'll be discussing the Fair Housing Act, tenant rights, and the eviction process. Next slide. So we'll focus on eviction procedure, some landlord-tenant rights and obligations, and how the FHA applies to LGBTQ rights and immigration status. Next slide. So just refresh everyone's memory, the Fair Housing Act protects people from discrimination when renting or buying a home on the basis of one of these protected classes: race, color, national origin, religion, sex, familial status, and disability. It covers landlords and other providers of housing, including real estate companies, homeowners insurance companies, banks, really anyone whose practice can make housing unavailable on the basis of one of these protected grounds. Discrimination is not only refusing to rent or sell a home, but also doing any other acts that would make housing unavailable to a person on the basis of one of these protected grounds. Next slide. So up until recently, LGBTQ protections were not included as part of the Fair Housing Act's protections against discrimination. That recently changed, and now LGBTQ protections are part of is one of the protected classes under the sex basis. So both sexual orientation or gender identity are now included as prohibitions against discrimination based on a person's sex. Next slide. HUD also requires equal access regardless of sexual orientation or gender identity in all its programs. So you cannot discriminate against persons residing in units that receive HUD assistance or are financed by a HUD mortgage. And I included the relevant regulations if you want to read them yourself. HUD also prohibits LGBTQ discrimination in HUD-funded shelter programs. If you are employed in a program that's HUD-funded or falls under one of these categories, you would be aware of that. Next slide. So in 2020, the Supreme Court decided a case named Bostock versus Clayton County, Georgia, which was actually an employment discrimination case. It involved 3 different plaintiffs who were terminated by different employers based on their sexual orientation or gender identity. One was transgender, and the other 2, I believe, were homosexual. So they all alleged that they were terminated on the basis of sex, and the Supreme Court held that firing a person for being homosexual or transgender is discrimination because of a person's sex. So now either sexual orientation or gender identity, or both of them, are covered under the protections against sex discrimination. So this was a very significant LGBTQ civil rights case, probably the most important one since the recognition of gay marriage in 2015. Next slide. So as a result of this expansion of protections against discrimination on the basis of sex, President Biden issued an executive order ordering all agencies to implement the Bostock ruling in their own programs. So now the Fair Housing Act also includes prohibitions against discriminating against tenants on the basis of sexual orientation or gender identity. Each federal agency was ordered to review its policies and take action to bring their policies and rules and procedures in accordance with the language of with the ruling in Bostock and with the Executive Order 13988. This executive order was issued in January, soon after President Biden took office. Next slide. So again, it implements this Supreme Court ruling throughout agencies that enforce civil rights laws. And now LGBTQ individuals have the same protections against discrimination that other protected classes receive. And we already covered the classes earlier. Next slide. I'll give you briefly some examples of LGBTQ discrimination and what it would entail. Say a gay man being evicted because his landlord believes he will infect other tenants with HIV or AIDS. This would be illegal disability discrimination under the Fair Housing Act because the man is perceived to have a disability. Say a transgender woman being asked by the owner of her apartment building not to dress in women's clothing in the common areas of the property would be a violation of the FHA's prohibition of sex discrimination. A property manager refusing to rent an apartment to a transgender applicant, if it is because of this prospective tenant's nonconformity with gender stereotypes, that would constitute illegal discrimination on the basis of sex. The discrimination can cover other individuals who are not directly involved in actually renting or selling a home. For example, an underwriter for an FHA-insured lender who's reviewing a loan application by two males. Let's say they're a homosexual couple. If this person assumes that the applicants are gay, denies the application, even though based on their income they would otherwise qualify, that would violate the equal access rule, which prohibits the lender from taking sexual orientation into account when deciding on an application. Same thing in a rental situation as well. Next slide. LGBTQ housing discrimination appears to be somewhat common. There are some older studies, including one from 2013, which showed that there is housing discrimination against same-sex couples, that heterosexual couples were consistently favored over gay or lesbian couples by a rate of about 15%. Another study found that gay men were charged higher yearly rent costs than heterosexual men. And the third study found that 19% of transgender persons were denied for housing that they applied for, and that 11% were evicted because of their gender identity, which would be a violation of the Fair Housing Act. Next slide. Let's cover how the FHA applies to immigration status. Now, let me start by saying that the Fair Housing Act applies to all individuals in the country, regardless of their immigration status. That being said, landlords do not have to act as an extension of immigration authorities by checking applicants' documents. Landlords however, may ask for proof of immigration status if they consistently do so. What they can do is request information from one person or group, but not from others. So if someone is dressed unusually, They cannot be asked for proof of immigration status if the landlord does not require that of all applicants. So what we're looking at is, are certain renters or home buyers treated differently because of one of these protected classes: race, color, national origin, religion, sex, and so forth. Next slide. Um, so these are some examples of things housing providers cannot do. On the basis of someone's immigration status or national origin. Evict someone, have rules unfairly targeting immigrants, for example, having them provide proof of status, say every 6 months, once a year, if that's not required of all tenants. Simply deny housing application because someone's not a citizen, deny that housing is even for sale or rent, or charge certain groups more rent or related fees. This should go without saying, but anything, any ad that would say immigrants are not wanted, or immigrants should provide additional proof of status would also be a violation. Also can't assign tenants to a specific area of a building or complex on the basis of any of these protected grounds. Next slide. So what happens if a tenant feels that their rights under the FHA have been violated? So we'll go through the process of how a tenant actually files a discrimination complaint and what happens. So the statute of limitations is 1 year, so the complaint must be filed within 1 year of the incident occurring. And here's a link where they would go to file it, both with HUD and with the Texas Workforce Commission. Texas has its own state FHA law, and also the Texas Workforce Commission enforces that. Next slide. After a complaint is filed, an intake specialist contacts the person complaining to get additional facts. Let's assume HUD has jurisdiction and it investigates. They will take down the information, speak to the complainant. They may even go and visit the property if circumstances require. There are some exceptions where HUD refers a complaint to another agency. If that happens, that agency has 30 days to begin to work with a complainant, or HUD can take it back. Next slide. So once HUD investigates the complaint, they'll interview the person complaining, the landlord, let's say is the respondent here, and any witnesses. Investigator may come out to the property and collect any documents that relate to the complaint. HUD will attempt a mediation process to see if parties can come to an agreement voluntarily. Parties are free to not participate if they don't wish to do so. If mediation does not work, HUD will finish investigating, and they'll either issue a determination that there is no reasonable cause and close the case, or they will find that the discrimination case did occur. A tenant, prospective tenant, can file an appeal or request for reconsideration, asking that HUD reconsider its decision. And after that, the complainant can file a civil action in federal court if they disagree with HUD's decision. Next slide. If HUD finds that discrimination did occur, they can issue a charge against the bad actor. That would be heard by an administrative law judge. Unless either party chooses to have it heard in a federal civil court, and parties have 20 days of receiving the charge to make that decision. If no one indicates that they want to be heard in federal court, a HUD administrative law judge hears the case and makes an initial decision. Within 15 days of that decision, either party that's adversely affected can petition the HUD secretary to review the decision. Then the Secretary of HUD has 30 days to either affirm it or change it, or send it back for further proceedings. If the Secretary does not do anything with the complaint within 30 days, the decision is the department's final decision, and can no longer be appealed within the agency. Next slide. Let's discuss retaliation. Now, The Texas Property Code prohibits landlords from retaliating against tenants for example, exercising their rights under the Fair Housing Act. So retaliation is defined as taking adverse action against a tenant because the tenant tried to exercise his or her rights. This provision is in effect for 6 months after the tenant's action. So some example would be of retaliation would be the landlord wrongfully terminating the lease, filing for eviction, depriving tenant of the use of the premises by locking them out, for example, decreasing services to tenant, suddenly not responding to repair requests, things like that, or increasing the rent. Next slide. So an example in a timeline of retaliatory case would be tenant requesting repairs or filing a fair housing complaint. If the landlord takes any adverse action against a tenant within 6 months of the tenant doing this, landlord is presumed to have retaliated against the tenant. Now, there are important exceptions. If the tenant receives a notice to vacate, we'll cover that in a moment, but it's how an eviction begins before requesting repairs or filing a fair housing complaint. That would not be considered retaliation. Or non-payment of rent. If the tenant does not pay rent, filing an eviction against them is of course not retaliation, whether they complain about fair housing or not. If a tenant files a suit in Justice of the Peace Court for retaliation, let's say they prevail, they can get a judgment against the landlord and damages in the amount of 1 month's rent plus $500, as well as attorney fees and court costs. Of course, either party can appeal to the county court of law if they're unhappy with the Justice of the Peace decision. Next slide. So here we'll run through some basic Texas eviction rules. An eviction in Texas starts with a landlord providing a tenant with a written 3-day notice to vacate. If the lease you signed with the tenant provides for less time, then you can also that controls, and you can provide less time if the lease specifies. If the tenant does not move out after receiving this notice, then the landlord can file an eviction suit. The formal name in Texas for it is forcible entry and detainment. Tenant has to be in a breach of the lease. Most commonly, that would be non-payment of rent. Next slide. If you have tenants who have vouchers, Section 8 vouchers, or you're in a project-based rental assistance property, which has a contract with HUD to provide housing for low-income clients, then these next few slides apply to you. Otherwise, they do not. So, good cause is required for eviction in subsidized housing. If it's public housing, HUD multifamily, low-income housing tax credit, supportive housing, these are very specific programs that you would know if you're a part of. For vouchers, including VASH, which is a Veterans Affairs program, good cause is required during lease term and at all times in an eviction control jurisdiction, which you don't need to worry about really. But essentially, if somebody is receiving a housing subsidy and they need to be evicted for good cause. Next slide. What is good cause? It's defined in the law as a serious or repeated violation of the terms or conditions of the lease or other good cause. So that would be criminal activity that threatens health, safety, or right to peaceful enjoyment by other tenants, drug-related criminal activity on or off the premises, engaged by the tenant or a guest under the tenant's control. If it's public housing, drug-related criminal activity can be on or off the premises. If it's a HUD multifamily property, on or near. Voucher, Section 8 voucher, also on or near. So these are specific instances where an eviction will also lead to the tenant losing their housing subsidy. That's why the level of proof is higher. Next slide. Same thing with tenant-based. Again, these are Section 8 vouchers for landlords who accept Section 8 vouchers. During the lease term, any serious or repeated violation, criminal activity, drug activity are sufficient good cause to evict them. Next slide. These are some examples. Non-payment of rent will always be good cause, obviously. In this case, it would be, if it's a subsidized property, that this would be the non-payment of the tenant's portion of rent. Breach of lease, some explicit provision of the lease that the tenant is allegedly breaching, having unauthorized occupants, unreported income, because tenant's portion of the rent is tied to their income. If they're not reporting income, that would be a serious breach because they're underpaying. Failure to pay their utilities, late payments, disruptive behavior, damaging the property, criminal activity or drug use, any fraud or misrepresentation applying, and failure to recertify. Tenants certify annually for these benefits, so if they fail to come and complete a recertification, that would be a violation of their terms. Next slide. Again, all this applies to subsidized housing, not general private landlords. But in these good cause cases, tenants commonly use the defenses that they're participating in a rehabilitation program, that a violation was harmless or small, that the person who committed a violation is no longer in the household. They can request reasonable accommodation. That would be, for example, if they're unable to pay by the 3rd of the month because their check doesn't arrive until the 7th, they can ask for reasonable accommodation to actually pay on the 7th without being charged fees. They can also request interpreters if they have limited English proficiency, and there are special protections under the Violence Against Women Act that really go beyond the scope of today's discussion. Next slide. So this now again applies to evictions generally. So regardless if they're subsidized or not, once you file an eviction in justice of the peace court, the only issue is immediate possession, not title. So justice of the peace only decides who has the superior right to possession, not who actually owns the property. So if, an example, two sisters file an eviction against two brothers based on a deed that their deceased mother signed, turning the property over to the sisters, this is really a title dispute because there is a pending suit in a probate court. So if it's in an eviction, you cannot evict someone if they are part owner or if they have a right to title. Generally, this does not apply in the context of an apartment eviction, usually in cases involving family members. Next slide. So you file the eviction in the precinct where the property is located. Tenant will be personally served with a citation by a constable. If the constable is unable to find tenant, you can ask the court for an alternative form of service, and we can cover that later. There are some specific provisions. Once eviction hearing is set, both parties should appear in court to avoid either a default judgment against the tenant if the tenant doesn't show up, or a dismissal for want of prosecution if the landlord or their agent doesn't show up. Let's assume that the landlord wins and tenant loses. Tenant is ordered evicted. Tenant has 5 days to vacate the property or to appeal the court's decision. If the 5th day falls on a holiday or on a weekend, the tenant has until the 1st business day when courts are open following that weekend or holiday to file an appeal. Next slide. So before filing the eviction, landlord must terminate the lease. Look at the language in the lease for the details. In most standard landlord-tenant leases, that's a 3-day notice to vacate. Or if the parties are on a month-to-month lease and the landlord simply doesn't want to renew the tenancy, they first have to give notice of non-renewal in accordance with the terms of the lease, usually 30 days notice, and then the notice to vacate. Different rules for Section 8 federally subsidized housing. So if you have one of those situations, that would really be a separate discussion. Next slide. Important to notice that the notice to vacate you give the tenant initially before filing the eviction does not need to include reasons for the eviction. There's nothing in the statute that requires the landlord to give a reason for the eviction, but the better practice for the landlord is to say, we're evicting you for non-payment of rent. Please vacate in 3 days. Next slide. So landlord must give the notice to vacate in person or by mail, either by personal delivery to a tenant or any person residing in the premises who is at least 16 years of age. Personal delivery to the premises by affixing it to the inside of the main entry door, or regular mail addressed to the premises, or certified mail return receipt requested. Notice period, these 3 days are calculated from the day when the notice is delivered, not when it is mailed. Next slide. What can the landlord ask for in an eviction suit? If the rent is payable monthly, each rent is a separate independent cause of action. So landlord may sue for rent, but not other amounts like damages to the premises, things like that. The tenant cannot bring counterclaims and say, well, I will sue you for something else, like not repairing something I asked you to repair. Also cannot add third parties to the suit. This is really just possession of the premises. And landlord may seek attorney fees. Next slide. You may have had cases where you're evicting a tenant and without an attorney present, non-lawyers may represent the landlord in eviction suits in justice court, only in cases for non-payment of rent or where somebody's holding over, meaning they remain in the unit once their lease is over. And so non-lawyers can request and obtain default judgments in eviction cases as well. Those are some exceptions to non-lawyers representing parties in Texas courts. Next slide. Again, either party has the right to appeal 5 days from the date of the Justice of the Peace Court judgment. Once the appeal is perfected, the Justice of the Peace judgment is vacated. It means it no longer exists. It becomes a whole new eviction suit in county court of law. The Justice of the Peace will set an appeal bond, meaning an amount of money that the losing party pays into the court's registry to perfect the appeal. If the tenant is unable to pay that, they can file a pauper's affidavit and continue to with the appeal. If the eviction is based on non-payment of rent, tenant has 5 days from the date of filing the pauper's affidavit to deposit 1 month's rent into the Justice of the Peace Court's registry, and then each subsequent monthly rent will be paid into the court's registry. So that ensures that the tenant maintains possession of the premises while the case is pending. If the tenant does not deposit the rent, the landlord may ask for a writ of possession while the appeal is pending. And the writ of possession is the actual order that directs a constable to remove tenants from the premises. On appeal to county court, landlord may also recover damages suffered for withholding or defending possession of the premises, so which would not be available in Justice of the Peace Court. Next slide. So the actual physical removal of a tenant from premises only happens when a writ of possession issues. So tenant can only be physically forced out once that writ of possession is issued by the court. And that issues after an eviction judgment is final. So if a tenant, say, loses in Justice of the Peace Court, they do not file an appeal within 5 days. On the 6th day after the judgment, the landlord can request a writ of possession. The writ is served by the constable, and tenant and all occupants will be contacted by the constable, will be given 24 hours to leave the unit before they're actually physically removed. Next slide. We'll briefly cover the CDC moratorium on residential evictions. It is no longer in effect, but this was an order that prevented evictions for non-payment of rent due to COVID-19, and it was in effect for about 1.5 years. still allowed evictions to proceed if there was any kind of criminal conduct by a tenant. It is no longer in effect. And if you have a case that was suspended, why? Because of the moratorium, you can contact the court and have it set for trial. Next slide. So, having covered a lot of grounds, in both fair housing and the process for evictions, there are some best practices in landlord-tenant relationships. For landlords, the safe option is to maintain consistency in accepting applications, enforcing rules and regulations, and communicating with tenants. You can encourage, but you can't require written communications. As we heard earlier, for example, a reasonable accommodation request, a landlord can't require them to be in writing or in any particular form. But landlords should encourage written communications, whether it's about repairs, lease extensions, any violations. Responding promptly to tenant concerns goes a long way, because these problems tend to kind of build up until they explode and someone goes to court. And clearly posting and enforcing property rules without selective enforcement goes a long way. Tenants talk to each other, and people get upset when someone is disciplined or warned for something that they see other people doing and not being warned. So, so much for me. Thank you very much. We can go to a questions and Q&A now. Oh, and here's our intake line. If you have any specific questions about your case, you can contact us and go through the application process.
Thank you, Velimir. Appreciate that. That was a lot of great information. I hope you guys were taking notes. And I'm sure people still have some questions. So we're going to take about 20 to 25 minutes to try to get through almost 40 questions. So we probably don't have time to get to every submitted question, but we will do the best that we can. I am going to ask a few questions to our industry experts, and then we will continue to take questions from the chat if time allows. So, one question is, with respect to reasonable modification, what if there is not enough parking spaces to make a modification for all handicapped residents?
Great question. You have to think, when somebody asks for a reasonable modification, think singularly, not collectively. You know, the old thing, did you bring enough, you have a piece of candy, did you bring enough for everybody? Don't think that way in reasonable modifications. It's specific as to that request, that individual. So unfortunately, we've had senior properties where they say, I can't grant you this parking space because everybody's going to ask for one, because everybody probably qualifies as having a disability. Well, unfortunately, the last person in line may lose out, but you need to take each request singularly and say, okay, do they have a disability under the Act, and do they have a disability related need for this modification? If they do, then you are obligated to give that to them. If you don't have one left, that's easy. You cannot do one. You can't create one. It's okay to not provide something if you can't possibly do it. It would provide an undue financial and administrative burden to buy a space for them to be in. So you could say no, but it's only on the ones that you just don't have any left.
Great, thank you. Now, this one is specifically about charging a deposit. So either one of you guys can take this. I normally charge a deposit from individuals who are not a family member, i.e. roommates, non-married couples. And so the theory is that one of the tenants, if one of the tenants leaves holding the bag, so to speak, their deposit will help the financial issues caused to the remaining clients. By charging this deposit to each client, is that being discriminatory?
Belmer, I leave that to you.
So to understand, if the parties are unrelated, charge if the tenants are unrelated, they're charged a separate deposit or an extra deposit, but not if they're a family unit. Yeah, I think that could be an issue with familial status, because if you have a someone who's charged extra because they're not married or because they're not related, that could be problematic. On the other hand, it's also a deposit which is refundable. So I think maybe the better option would be to simply charge one higher deposit amount.
Okay, thank you.
Howard, you're off.
Oh,
Sorry, just said great things. No. You can't. HUD has made it clear if you charge a per person deposit, like Velmer says, that may impact familial status discrimination. So you got to be really careful if you're making it more expensive for families with children to live there versus people that aren't families with children.
that's fair. Thank you. Now, this is about eviction, and I know that you talked about this, Mr. Rosich, but can you speak a little bit more about how to evict one's own children? Um, what if the child is not willing to move out? And what are some actions that the homeowner can take?
So let me first say that I assume that the children are grown, that it's not your first grader. Uh, Assuming they're adult children and there's no title to the property, meaning that grandma did not leave the home to grandchild to your child to where they have an interest in the property, you move forward as you would with a with anyone else. You give a notice. I would give a 30-day notice. Treat them as basically a tenanted sufferance. Then a 3-day notice to vacate, and then file the eviction. Personally serve them. Go from there. Just because they are your adult child does not mean they have any specific protection against eviction. It may, of course, affect family relations, but those are likely already at a low point.
Thank you. Please don't evict your first graders, everybody. Okay, so this question is about pet policies. I have a client who was allowed a pet by the previous owner. I did not prevent him from keeping the animal. However, another new client has questioned this. Am I required now to allow all of the clients to have pets, even though this is not my policy to allow them?
A lot on that. I think that's a great question. I would say, though, you are not bound to always have a pet policy if you don't want one. So I would, you're certainly able to modify your rules. You just need to be careful, I would say, to phase out anyone who has pets. And this is not, I guess, an assistance animal. If it's an assistance animal, your no pet policy, you'd still be required to take an assistance animal that's properly qualified. But setting aside the assistance animal issue, just a matter of changing your rules, your pet rules, but you have to be somewhat considerate. You wouldn't be able to, for example, tell somebody, I've changed my rules and you've got to get rid of that pet for no reason, no conduct reason for the pet or you, we just change our policies. Well, they might have something to say about it because you assumed when you purchased the property, when your owner purchased property, chances are he assumed the obligations under all existing leases, including the animal addendum with the permission to have the pet. So you can't change that during the term, but you'd have to phase that out. But I would give somebody well in advance notice that we're changing our policies. You may want to move out at the end of your lease term because we're changing our policies. So I would set the policy and then work on phasing it with all people who are existing violators through the end of their term of the lease.
Great, thank you. Um, the next question is a tenant required, can tenants withhold rent for maintenance issues? And does this constitute a means for eviction?
Howard, you want to take this, or I can answer this?
You can chime in if I miss anything, but yeah, the only permission you have in the repair and remedy statute to withhold rent is if you withhold rent and you pay for the repair yourself if you're a tenant. So, and you have to follow a letter writing procedure with the landlord in order to do that. I have rarely seen it done correctly by any tenants, and tenants typically don't want to pay for the repair themselves. So no, you cannot withhold, a resident cannot withhold rent because a landlord's not repairing. In fact, it's really a bad idea because you lose rights as a tenant if you don't pay your rent. So don't do that unless you are, you have a lawyer helping you to repair, to pay for the repair yourself, and then it can be limited to only 1 month's rent. So there's a lot of rules that apply to that. But generally speaking, no, you can't withhold rent.
And the process is so technical that I advise clients not to ever do that. It's just not worth it. And if a tenant tries to do it themselves, it's almost a guaranteed eviction that'll follow.
Great, thank you both. Okay, another question is the HUD rule for not requiring requests in writing for modifications or accommodations for disabilities does exist, but does this apply to any accommodations or modifications? As in, I tried to require my request via email, but is the tenant in jeopardy if he does not make the request in writing?
No, HUD says you cannot require it in writing, meaning that you can't say no unless someone puts it in writing. You can't do that. So you would always adhere. You would always try to deal with any request you get, whether it's verbal or written. But the way to approach that, though, like I said in one of the slides, you respond in writing. Right, so you would confirm in writing as part of your response what you think their request is. And I often say, it's, you didn't put it in writing. However, based on our conversations, it's my understanding that you want da 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 da. And then if my understanding is incorrect in any way, please let me know. In other words, you're trying to work with the person. They're not your enemy, right? You're trying to work with them to decide what you want. And on modifications, it becomes, you have to be very specific, because if you're going to authorize a modification to your property, you want to know exactly what it is, what materials are going to be used, the size of something, the color of something. You're going to want to know very specific what is wanted and work with the resident from there.
Thank you. Another question from our chat is, what can be done if a landlord charges fees and the tenant has not been notified of until months later?
I didn't hear that. The tenant has not what?
What can be done if a landlord charges fees that the tenant has not been notified of for months?
Okay.
I'm not sure if that's clear enough. As in, the tenant wasn't notified for a while.
I have 3 rules on fees, okay? Number 1 is it has to be agreed to in writing in advance of charging it by the resident. So you should only charge fees that somewhere in your lease documentation the resident has agreed to pay it. If it's even if it's a violation fee, you'd want to get that violation fee. If you violate the pet policy, if you're going to charge it $25 per violation, whatever. But it should be in writing. Number 2, it should not be prohibited by law. The fees that I used as most examples of that is if you have a water billing fee of something in excess of what the PUC rules allow. They really don't. They allow a service fee for sub-meter, but nothing for allocated water. So it can't be illegal. And number 3, it's got to be reasonable in light of what the fee is intended to cover. If you're charging a $5,000 pest control fee when it costs you $5 to service a unit, that's not reasonable. So you want to follow those three rules. If a resident, so the resident in this question, I'm not sure if the resident agreed to it in writing before the resident was charged, it sounds like.
Thank you. Another question is about fair rent. Um, I have a Section 8, or I have Section 8 clients, and each voucher is at a different rental rate. Do I have to charge the same amount of rent for like properties? I.e., is this considered a fair housing issue?
So I'm not sure I understand that the landlord charges different rates based on what?
I'm assuming this is based on the property. The properties are the same, but they may charge different clients, or it would be a similar unit, different client at a different price.
Hmm. Well, I'm not sure how the landlord is pricing the units. If it's in the same complex, is every, say, two-bedroom of the same size charged the same rate?
I think we have a clarification in the chat. It's because of the voucher rental rate.
The tenant's portion will depend on their income. So if the tenant charges $1,000 for every two-bedroom apartment, each tenant's portion will be different based on their income. If they have zero income, the HUD's portion may be 100%. If they have some income, they'll pay 30% of their their rent portion, and the voucher covers the rest.
Yeah, I think we'd have to look at the details. Obviously, there are companies, legitimate pricing can be real-time pricing based on supply and demand. So it's the market that's going to dictate your rental rate. But having said that, you can't, at the same moment in time, let's say you have an African American applicant and you have a Caucasian applicant, you can't charge the applicant, the African American, more than the Caucasian, right? You can't charge somebody differently because of a protected class. But we've had a lot of cases where the morning prices may be different than the afternoon prices, just because you have a real-time sort of pricing fluctuation. And there's nothing against that, but you may have to justify it that it was a legitimate business interest, not because of a protected class. Now, if you're saying you have one rate for the Section 8 residents and one rate for market residents, we'd have to look at what is your business justification for that. And I'm almost assuming in that you're charging the Section 8 residents less than the market residents. But again, market residents come in all types of protected classes, so does Section 8 residents. So we have to look at that and analyze it. Is there any argument that you are charging based on a protected class? That is a no-no. But if you're charging based on what you would normally charge apartment communities, then it might be okay.
Thank you. Thank you both for trying to answer that. I think if you need more details on that for this particular issue, you may want to get some legal advice here on that one. I have another question. What if I have a nuisance renter and I choose not to renew their lease? How do I protect myself from a fair housing complaint?
Simply not renewing a lease because somebody's committing violations would not be a discriminatory thing.
I'd say two things that you have to be careful of when you're terminating a lease at the end of the term. Yes, you have the right to do it. both parties can give whatever notice is required under the lease to terminate the lease at the end of the term or any month-to-month renewal. But two things do come up in that environment. One is retaliation under our Texas laws, and the other one is discrimination under the Fair Housing Act. So you're not required legally to do what I'm going to suggest now, but I think it is a good strategy to show the judge if you have a retaliation or discrimination claim come up, that you didn't just make your reason up at that time, you had it all along. So what I say, oftentimes what we'll do is we'll terminate a lease because the resident has defaulted. We just don't want to make a big deal out of it and give them a 3-day notice to vacate. So we'll give them a 60-day notice because their lease is up anyway. We'll give them a termination notice. And so what I do is I actually put in my notices the real reason why they're being treated different than others who may be renewed at the end of their term of the lease. It's because we've had constant noise complaints. You've been late every month in payment. Something where maybe you wouldn't want to go forward on a 3-day notice to vacate, but you're okay going to terminate the lease. But tell them why. I think it's fair to tell them the real reason. So that's kind of a strategy call, not what's legally you don't have to give them a reason.
Thank you both. So now I'm going to wrap up with one more question. And this was a question that was posed in our last session, but I think it's very pertinent given the new rules on gender identity and sexual orientation. For people of the LGBTQ plus community or that are transgender, how can we address when the ID does not match the person that is in front of us? For an instance, your ID shows a male with a male name and a picture, but you have a female in front of you. What should you do as a landlord or property manager?
I would say that in those situations, the landlord can ask for further information. Obviously, if you're getting an ID, a person that looks nothing like an ID, you don't know if they're transgender, not say anything. You are entitled to say you do not match the person on this picture. So ask for further documents, some kind of proof of either identity that will satisfy you as a landlord that you are actually dealing with a person that they say they are. You're not denying them. You're simply asking for more info.
Howard, you're on mute.
I would argue you're treating them like everybody else by confirming their identification. So you need to know who you're renting to.
Thank you. I think that's fair. I think I have one more question, and this will be the last one. I want to make sure that we get everybody out on time. In regards to the ESA animal, when I try to ask for information about the condition in which an ESA animal is being requested, I get a reply saying that we are not required to provide you with that information because it's medical personal information. How should a property manager approach this situation?
All I do in my responses to requests for ESAs, if you're not granting the request, remember I err on the side of not denying, so I ask for more information. I don't ask for specific information. I tell them I reiterate what they gave us in support of their initial request. I tell them what the problem is with that. If it's a form letter, then it's clearly it's a form letter, there's no personal knowledge. And then I say, based on the information, it warrants further questions. And then I ask them, we need information to verify. It depends if you're sold on the disability, don't ask this, but verify that you have a disability under the act and verify your disability related need. We just need further information on those things. And that's what I ask for. I don't say have the doctor change his note to say personal information, or have a different doctor. I don't think the Fair Housing Act allows you to get into the weeds on what they can provide. It just requires that you evaluate anything they give you for those two things. And I think it's fair to re-ask those questions, but I would also think it's fair to tell them why, it's vague, conclusory comments like the case that I went through. Why is the information they gave us not sufficient? It's because of that, and we're asking for further information. But I understand it's frustrating for both landlords and tenants because HUD doesn't really allow the landlord to ask specific questions other than those two vague questions, and it doesn't tell tenants what you can absolutely provide for us to say yes. So it's frustrating, but I would stick to that and keep judging what they give you. And if you have a credibility problem or something else with the stuff they give you, you've got to just ask them for further information to show your disability and show your disability related need for the animal.
Alrighty. Thank you both so much. I just want to extend my appreciation to you both. You provided such great information and answered all of these questions. I know some of them were a little tricky or vague at times, but thank you so much for attempting to answer them all. We didn't get to everybody's question, but I thank you all for your patience. Hopefully, we'll be able to do this session again in the future and try to answer more questions for you guys. Right now, I really want to go back to our poll and let's see what you've learned. It's my greatest hope as a presenter that we have provided great content to you guys that is applicable to the work that you do every day. So please tell us again. Hopefully, your knowledge base has increased. 5 being the most confident that you are in applying your fair housing responsibilities, and 1 being the lowest. Hopefully, you're not at a 1 anymore after today. Thank you. Great. 4s and 5s. I love it. I love it. Dolores, hopefully we can continue to provide you with more information and help you out and get you the information that you need. Thank you, Marcella. I love the comment and the feedback. Thank you. Thank you, Gail. I appreciate it. And Georgia, thank you. I hope it was amazing to all of you all. Great. Well, I love to see that. We're going to close out, guys, and we just have a few reminders for you. Our fair housing team has a plethora of outreach materials that you can use and share with your communities. We have downloadable fair housing information in 6 different languages on our website. And we also have a landlord tenant fair housing hotline that is free to any caller. The hotline is a great resource, and we want people to know that they can call at any time. Please tell your tenants about this. And landlords, you are also welcome to call and ask questions. And finally, we have a fair housing team that is available to give presentations about any fair housing related topics. Most of these include residents' rights under the Fair Housing Act, tenant and landlord issues, and fair housing complaints. So we are happy to present this to any type of audience, including your property management staff. So please email Ms. Kimmy Johnson if you're interested in utilizing us as a training resource. And lastly, our rental assistance. Just a reminder that if you have a tenant that is struggling to make their payments in a timely fashion, they have been impacted by COVID, please refer them to HoustonHarrisHelp.org to see if they qualify for assistance under this program. The information to the hotline for this program is also on the screen. You can call that number if you have questions as a landlord as well. And please don't forget to enroll. And lastly, I keep saying lastly, I promise this is the last bit. There's a link to a feedback survey in the chat about this workshop. If you loved us, please fill this out. Tell us if we've done a good job and how we can improve. You'll definitely receive the survey via email along with presentation slides. So please look out for those workshop materials. This will also be posted on our website as well. And with that, if you haven't done so already, please follow us on Facebook, Instagram, Twitter, and LinkedIn, and hit those like, follow, and subscribe buttons on all of our platforms. Thank you again. And until next time, stay safe. Thank you.